მოგესალმებით თვირფასო ქალბატონებო და ბატონებო დილომშვიდობის. იმედი მაქვს რომ კონფერენციის პირველი დღე თქვენთვის საინტერესო იყო. იმიტომ რომ არაერთმა უმნიშვნელოვანესმა საკითხმა გაიჟღერა. დღეს უწყვეტ რეჟიმში განვაგრძობთ კონფერენციის მეორე დღეს. გაგაცნობთ დღევანდელი დღის წესრიგს. გადავინაცვლებთ პირველ პანელურ დისკუსიაზე. Welcome back to the second day of the international conference. As we now begin, I invite you to join for the first panel discussion, Competition Policy Enforcement in Digital Markets, Challenges and Best Practices. Please welcome to the moderator, Mr. Levan Vephuadze, and panelists Lucas Cavada, Peter Holzenbein, Cosmin Belankurenu, and Bulet Achma. Please welcome. წარმატებულ და სასიამოვნო დღეს გისურვებთ და მოგიწოდებთ მაქსიმალური ჩართულობისაკენ. მადლობა.
Thank you for the introduction, our panelists. We start at 11 Georgian time, of course. And I'd like to, my position here, you know, I have no background of working with regulatory bodies like competition agencies. I have no experience working with the law, but on the other hand, I represent business community, and that's why for me it's a great pleasure to have these esteemed guests from 4 countries with maybe 4 different approaches, 4 different experience and backgrounds. And you know, for me as a moderator, there are a couple of questions which I think that we will discuss today. And besides the presentations and regulations from your 4 countries, I think that we have to raise the question about the goals of these kind of regulations. You know, digital commerce has becoming after the COVID blooming industry in Georgia. I think this is the same in your countries as well. And a lot of companies which has retail industry, they moved from the kind of real life from digital market, and they use this kind of platforms for their selling their products, services, etc., etc. But you know, when we're speaking about digital markets, another interesting topic rises. It's about innovation. And for us as a business, innovation, one of the drivers for digital commerce during the last years. We started with almost nothing a couple of years ago, but now we have a lot of interesting platforms selling our products. We have different approaches, different commercial, I would say, paths how to get the final consumer. But on this path, you know, there might be some problems with the competition. But, you know, for me, competition in digital markets and competition sounds like oxymoron, you know. It's open space. Everyone can compete with each other in this space. And this is my first question for all of your representatives. How do you see competition and the problem with the competition, with the problem of market collisions, with the problem of abusing the market power in digital commerce? What does it mean? Is it oxymoron, or is it we have real kind of cases how a company can create and abuse its kind of this power, antitrust power? And another one, you know, finally, I think that during the cases, we have to go over these issues, and I think that the final part of our presentation will be live discussion with the audience. I think you are so brave that you will answer all of these questions that are coming from our audience. But at first, let me introduce our honorable guests from 4 countries. I mentioned these countries. These are Romania, Turkey, Austria, and Germany, of course. And let me start with Lucas Cavada, which is Executive Coordinator for International Relations at Austrian Federal Competition Agency. And he is, of course, responsible for international cooperation because he represents this part of the Federal Competition Authority. It is interesting to know that Mr. Kavada has a lot of he published a lot of articles and delivers lectures on competition law. What about the background? He has background of law from the universities in Vienna and London, and now he's completing doctoral degree at European University Institute. The next, our honorable guest represents Romania, and I think it's quite interesting to mention that represents the National Competition Authority of Romania, RCC. Cosmin Belacurenu, member of the Romanian Competition Council. And as a background, Mr. Belacurenu has the background of Faculty of Economics at the Bucharest University of Economic Studies. And of course, he has extensive experience in state aid, antitrust, European affairs, and international relations. Of course, he has delivered speeches at various international conferences, seminars, bilateral meetings, and I think that it should be noted that Cosmin has participated in numerous public awareness campaigns carried out by the Romanian Competition Council, and of course promoting competition culture and disseminating knowledge about competition policy. Our next honorable guests represent Germany. Federal Cartel Office. It sounds quite interesting, unlike other institutions, Federal Cartel Office. And Mr. Holzenbein, he's a senior case officer at the German Federal Cartel Office. Interesting to note that Mr. Holzenbein has also background working with the private companies before 2005. But from the year 2010 up to 2013, Mr. Holzenbein worked at the Directorate General for Competition of European Commission in Brussels. And that's why it's quite interesting to have the European perspective from his presentation. And the last but not least, our honorable guest from Turkey, Bülent Ançpa. He represents more academical part of our panel. Mr. Ançpa is an expert in international economics and economic development and is a distinguished researcher and professor of Anadolu University in Turkey. And this group, Anadolu, is quite famous for us in Georgia as well, because Anadolu has a couple of large-scale projects here in Georgia as well. Mr. Ançpa leads the Department of Economics in the university. Of course, it is a well-known academician with his 50 published articles, 5 books, and also it should be mentioned, that Mr. Ançpa, he's in the editorial boards of more than 20 journals, academical journals known worldwide. I'd like to stop here, and I think that it's better listening our guests. Let's start with Mr. Lucas Cavada. The floor is yours.
Good morning, everyone, and please allow me to start Didi Matlova to the GCCA and other organizers for this fantastic conference. It's an honor to speak with you today about one of the most pressing and transformative topics of our time, the digital economy. And so much has already been said in the introduction. I want to echo that and perhaps add that I believe digitalization has not only reshaped how we communicate, work and live, but also introduced new regulatory and economic challenges. As we as competition authorities strive for a fair and transparent digital landscape, we as competition authorities need to address several pressing issues. And today in my presentation I want to focus briefly on 5 key areas. First, the growing landscape of regulation, competition law cases from Austria, merger control, and challenges posed by vast volumes of data and the role of collaborative initiatives in shaping the future. Can we please move to the next slide? Thank you. Sometimes it's challenging with digital issues, so I think it perfectly fits into this topic. And I just want to briefly mention, right, there is a lot of regulation out there. I think you know most of these regulations. So at the European level, of course, we have the Digital Markets Act and Digital Service Act. And not to forget about the regulation promoting fairness and transparency for business users of online intermediate services. So I think it's fair to say that these laws aim to ensure that dominant platforms operate transparently and do not abuse their market position. So to come back to Austria, at the national level, we have extended our competition laws to address digital issues. And what's notable is that these laws are not merely theoretical. They have been actively applied, and I think that's very important, leading to real-world investigations and enforcement activities. This is a strong signal also to business, I believe, because compliance in digital market is not optional, if you wish, but essential for sustainable growth. As digital markets grow, so does the focus of competition law and investigations. Historically, vertical agreements, such those between manufacturers and distributors, have not always been a top enforcement priority. However, recent cases in Austria illustrate that digital is not always big tech related. So, for example, we had cases that concerned Thalia, that is a prominent bookstore chain, and it was fined for engaging in online price fixing agreements with manufacturers of school bags, actually. So we had a similar case where online restrictions resulted in a fine for a company, and one case concerned DeLonghi, which some of you may know, and this case involved restrictions on cross-border trade and internet sales, and leading to a fine of almost €1 million. I hope these examples underline the importance of vigilance in adhering to competition laws, especially in the digital age. And they also highlight, in my opinion, how national authorities are addressing the nuances of vertical agreements, cross-border trade restriction, and online sales monitoring, because digital, as I said before, is not only big tech. So second point concerns merger control, and I think it's fair to say that it's an important tool for safeguarding competition also in the digital economy. And Austria has introduced in 2017 a so-called transaction-based value, similar to Germany. This is a proactive approach to preventing monopolization, especially in digital markets, because the threshold ensures that even transactions involving low revenue but high value targets, which is quite common in the digital area, are subject to regulatory scrutiny. And I think in this context it's important to mention two recent examples. One concerns the acquisition of Giphy by Facebook, now known as Meta. This case was notifiable in Austria because of the transaction-based value. And the case raised concerns about integration of data assets and market power consolidations. And the second case I want to briefly mention concerns Adobe's acquisition of Figma that was also triggered because of the transaction-based value and eventually referred to the European Commission. And there was also competition concerns on innovation in their respective business areas. Both mergers were eventually blocked by the respective competition authorities and were only notifiable because of the transaction-based value. Last but not least, I want also to share with you perhaps one of the most impactful investigations in recent years. They involved Amazon, a company you all know very well. And there were parallel proceedings in Austria and in Germany. So what happened between 2017 and 2018, multiple complaints were filed against Amazon, citing issues like unjustified seller account, suspensions and withholding of funds. And these allegations pointed to a potential abuse of dominance. In response, we conducted a market survey, and that basically confirmed our competition concerns. And quite important, the investigations led to meaningful changes in terms of conditions. So now Amazon no longer can terminate or suspend contracts, and the company is now restricted in use of seller-provided materials, ensuring fairer terms for small businesses. Yes, I think it's a very interesting time also for competition authorities. I know we are speaking a lot about artificial intelligence. So, yeah, what I can share from an Austrian perspective is that we try to establish a unit that is dedicated to AI in order to fully leverage the potential of AI also for competition authorities. So, of course, we are facing some challenges, and I will be frank and open in that respect. It's a matter of access to data and also the availability of cloud storage, just to name a few. But I think it's important that we have this as a priority because I think it's a necessary tool in our toolbox, and it will certainly shape the future quite kind of disruptive. So my last slide deals with an initiative that was actually signed last week in Austria. So it's fair to say, I think, that recognizing the interconnected nature of digital issues, we have set up a network in Austria. And this initiative brings together independent authorities and regulators. So that is us, the energy regulator, the data protection authority, the telecoms regulator, and the media regulator. And the main aim of this network is the collaboration, because I think it's vital for tackling cross-sector challenges from data privacy to telecommunications. And I hope it demonstrates a forward-thinking approach and that we want to shape the future together. So I think my time is up. I thank you for your attention, and I'm looking forward to your questions. Thank you.
Thank you, Mr. Kawada. Thank you. You have quite interesting names: Facebook, Amazon, Adobe, which are also famous here. And thank you for illustrating how enforcement should adopt to the growing impact of this kind of platforms. You know. Thank you. The next our guests will be Mr. Peter Holzenbein, and I think that Mr. Peter will give us not only national but also kind of European perspective and context.
Okay, thank you very much. Hello to everybody. Thank you for the introduction. First of all, I would like to take this opportunity to thank the GCCA and the organizers of this wonderful conference. Georgia is famous for its hospitality, and already after being here for just over 24 hours, I can sense what everybody is talking about. Last night we had a very lovely evening. It was really delicious and very entertaining, and to be in such company was already worth the trip for me, so thank you for that. I also very much appreciate that I have been invited to contribute to this panel to talk about digital markets. And as been just mentioned, some time ago I spent a couple of years with the European Commission. This was actually the first time that I personally had to do with digital markets. I became a member of the case team that for the first time initiated a number of proceedings against Google, and the first case started around about 2009, 2010. And this first case later became the Google shopping case. It was about how Google presented its search results. There were a number of different complainants claiming that Google would promote its own services and at the same time demote its services, the services of its competitors. So Google would put its own services on top of the search results and place those of the competitors below, or even on the second page, which in practice means that, or it comes close to not showing them at all. Initially, we started to look at a number of different specialized services, but the case eventually focused just on Google Shopping and price comparison sites as just one particular service. And 3 years into the case, I left the Commission and went back to the Bundeskartellamt. And by then, the case was still going on, and it took my colleagues another 5 years to conclude it with a final decision. And it was only like 2 months ago that when Europe's highest court, the European Court of Justice, eventually confirmed the infringement decision that covers a time span of around about 15 years from the beginning of the proceeding to its final conclusion. So there are a number of very good reasons why which might explain why it took so long to get to a grip on this single abuse case, but I guess that you will all agree that 8 years to reach an infringement decision and another 8 years to have it confirmed by the courts is by far too long. So it favors only those who don't play by the rules. And one major problem certainly is that digital markets tend to move faster and faster and on every end, and that at the same time competition law cases have become much more complex, both on the facts and the law. But I don't know, what do I have to do? Here we go, thanks. But what is it about digital markets that makes them so special in comparison to other more traditional markets? This is what I would like to focus on today. Some of you may already have been dealing with that or be aware of those issues, but I think it's worth it to just to repeat it or to take everybody on board on that. And the debate about large digital platforms has also recently led to a number of new legal tools. And as a second point, I would like to briefly highlight what has happened at the EU level and in Germany in that respect. And finally, if time permits, I'm aware of certain time constraints here, I would like to conclude with a short outlook on what lies ahead. So what is it about digital markets that sets them apart from more traditional sectors? And one way of looking at this is maybe by looking at the business models applied by large online platforms as opposed to the business models that you will see in traditional markets. And traditional business models are very much more straightforward. They tend to be one-sided. You create a value for me and I pay you in return. So it's more or less a simple exchange between a supplier and a customer. And this also means that at the outset there's only just one clearly defined market which is directly concerned. And for a competition authority, it is, at least by comparison, quite easy to get a grip on those kind of situations, where you can have a clearly defined market and where you can ask competitors and customers to assess how strong your position is and how your behavior affects a competition. So this would be like the traditional approach, how we approach usual cases. But in digital markets, it doesn't seem to get that easy. You often encounter business models that are and ecosystems that are much more complex than what you see in more traditional sectors. Like the likes of Google, Apple, Amazon, and co. entertain large multi-sided platforms. Over these multi-sided platforms, they offer complementary services to different customer groups. But what is more important, the economics of these digital platforms differ to some extent from the economics in traditional markets. And one feature is that some of the services of these platforms may be offered for free on one or more sides of the platforms. There will usually be the end-user facing side, and monetized on other sides of the platform, in particular the business user side. For instance, if you use the Google search engine or Google Maps, you don't have to give Google money in return. The service is free, if you will. And in Germany, we used to have some discussions if we could assume a market in those kind of situations at all. But of course, we do have an actual market here. For instance, Google is happy to have your eyeballs, which is just another word for your attention, or your data, which Google monetizes somewhere on other sides of its platforms by providing services, for instance, to advertisers, or by creating or improving services that they can sell on to other business users. So you are actually always giving Google something in exchange for using its services. Or, as the Nobel Prize-winning economist Milton Friedman has once put it, there's no such thing as a free lunch. From an economic or competition law point of view, it can be difficult under those circumstances to just look at one particular side of those platforms and consider this side in isolation as the relevant market. And if you want to come to any conclusions on what the platform is actually competing on and whether the platform competes on the merits, you will often only get a complete picture if you look at the platform as a whole. You really need to understand the underlying business models, and that can be quite challenging. In particular, if you take into account that you're dealing with very innovative and adaptive ecosystems in a highly dynamic environment. So you're literally dealing with moving targets in many respects. So there has been a lot of debate in the past about digital platforms and the economics, about direct and indirect network effects, and so forth. And this debate has just been fueled recently by highly dynamic developments, such as the emergence of generative artificial intelligence and cloud computing. And everybody is right now trying to keep pace with all those new developments. And I've just been signaled that I need to wrap up already, even though there's still some points that I wanted to mention. At the EU level, we now have the Digital Markets Act, and this act specifically aims at services that constitute important gateways for business users to reach end users. So the DMA is actually head-on, exactly focusing on those platform services that act as some sort of a link or intermediary between business users and end users. And the DMA tries to keep it as simple as possible in order to be as effective as possible. And it tries to get rid of what has made competition law enforcement so burdensome, in particular with regard to digital platforms. We have a similar tool in Germany that is that we call Section 19A, and that is applying to platforms with paramount significance for competition across markets. It's somewhat a similar approach to the DMA, but it has a broader scope, and we think it is more flexible and open, so that we can take kind of new developments and new insights. and it's meant to complement the DMA. And we have a number of cases which we are in close contact with the European Commission about, where we actually try to look at loopholes and what is just happening next to the DMA. In particular, we are looking at cases regarding business-to-business relationships, which are not covered by the DMA, for Google Maps and the Google car operating system, which Google intends to sell to every large car manufacturer right now. Okay, so you can see that a lot is going on. We are still ramping up all those enforcement issues, and we really need to stop at one point and take stock and assess their impact. And what we have really actually learned is how important it is to coordinate and cooperate in relation to digital markets. It is much more important there and in many other areas that we used to work at. But not only with competition authorities like us and the European Commission or within the International Competition Network, but also with other sector regulators like data protection authorities, consumer protection authorities, because often you have close links that have already been mentioned yesterday. And I think what is also important, but we have covered that already, is merger control, and how we can get a grip on developments very early, because one issue there certainly is that we don't really can foresee what is happening there. And the Commission, I think in 2013 or something, cleared the acquisition of WhatsApp and Instagram by Facebook, and was now Meta. And what we actually see today is that in America they are trying to divest exactly that, so reverse that merger and to make Meta to sell Instagram and WhatsApp, and divestitures is certainly something at one point one actually has to look at if we think that behavioral measures don't suffice anymore. Thank you very much.
Thank you, Mr. Holzenbein. We just speaking about the usage of digital by the digital platforms, the big data analytics for the converting it and monetize it, selling themselves and creating value for themselves on the market. But these tools can be used even for authorities. Big data analytics. I think that Mr. Belacurenu, representing the Romanian Competition Council, also dealt with the big data project in Romanian authorities, and I think that authorities can also use this big data for the understanding the market and use tools against the abusing the cartels and etc. etc. Yeah, Mr. Belacurenu, the floor is yours.
Thank you. Good morning, everyone. First of all, I would also like to thank to our colleagues from Georgian Competition Authority, and especially to the president of the authority for inviting me and my colleague Oana to attend this very interesting conference. I also want to thank for the hospitality. We are surrounded here in Tbilisi. Yesterday we spent a very, very nice evening. We had the chance to taste the amazing Georgian food and wines, and also to discover your culture. Thank you very much. Today I want to briefly present the Romanian Competition Council activity in the digital markets for the last 5 years. The big one, yeah. Okay. So I want to start by presenting two cases which are already finalized. Then I will continue with an ongoing investigation about Sony PlayStation. It's an ongoing investigation, so I only present to you the clues we had when we decided to initiate the investigation. And at the end of my intervention, I want to say a few words of one of our main projects within the authority, the big data project, and some challenges we face now regarding the digital sector. EMAG case. EMAG is the biggest marketplace platform in Romania. We call it the Amazon of Romania. EMAG has a dual role. On one hand, it's the owner of the platform. Companies which want to sell their products on the platform, they are allowed to sell the products, and at the end of the process, EMAG gets a percentage of the income. And on the other hand, EMAG sells its own products on the platform. So it's a competitor of the other sellers. During the investigation, we found out that EMAG abused its dominant position by manipulating the algorithm to favor its own products. In other words, if a person wanted to search, for example, the cheapest washing machine on the platform, and if EMAG sold washing machines on that platform, if the person wanted to find the cheapest one, because EMAG manipulated the algorithm, the cheapest one which was listed on the screen was a washing machine sold by EMAG, even if theoretically on the platform there were washing machines cheaper than the ones sold by EMAG. At the end of the investigation, EMAG decided to settle with the Romanian Competition Authority. We offered them a reduction of the fine, but even with the reduction, the total amount of fine imposed to EMAG was around 6.7 million euros. Another case is the Samsung case. I think all of you know Samsung is the Korean producer. So the parties which were investigated were Samsung and its retailers in Romania. It's a very important thing that we initiated the investigation after receiving a message on the whistleblower platform. So during the investigation, we found out that the infringement was related with agreements and or concerted practices to restrict the ability of retailers to independently set their resale prices. Samsung continuously monitored the sales prices of phones and the televisions sold by retailers and contacted retailers to change their commercial behavior. In other words, when Samsung noticed that one of the retailers reduce the price for one television, for example, he immediately contacted the retailers and trying to convince it to cancel the reduction, or in other occasions they try to convince the retailer not to offer a reduction of the price to the final consumers, but to offer a voucher. In this investigation, like in the previous one, all parties decided to settle with us, so they recognized the infringement of the competition law. In this investigation, we also had two companies which applied for leniency and the benefit of an additional reduction of the fine. and the total amount of fines imposed to all the parties involved in the investigation was 25 million euros. Now I move to one ongoing investigation, and because it's an ongoing investigation, I cannot offer you very much details, but I want to present to you which were our hints, clues when we decided to initiate the investigation. So I think all of you know that Sony sells PlayStation and video games for PlayStation. And before 2019, there were 3 methods to buy a video game compatible with the Sony PlayStation. First, the physical disc-based format, to go in a shop, in a retail shop, and to buy a disc. Then you could also go to a retailer and buy activation codes, and then you activate the codes and download the game. And the third option was to buy it from the Sony PlayStation Store. After 2019, Sony decided that the sale of activation codes through third parties retailers was excluded. And now the only possibility to buy video games is to buy physical ones, disc-based games. But this method, it's becoming a niche. So the percentage of the sales of the disc-based games is decreasing year by year. And now we only have one option. So the consumers who want to buy video games compatible with the Sony PlayStation can have only one option, to go to the Sony PlayStation Store and to buy it from there. In our opinion, so we had enough clues to start an investigation, and if you invite me next year to join the conference, I hope I can provide you the final decision of the authority. And at the end of, 2 minutes I can manage. At the end of my intervention, I want to present our big data project. So this project was initiated in 2018. It was financed from EU funds. Our main objective was to integrate the databases of the main important public institutions in Romania: the Romanian Competition Council, the Fiscal Administration, National Trade Register, Ministry of Justice, Public Procurement Electronic Platform, etc. Together with the company who developed the platform, at the end of the project, they helped us to design some algorithm, and our intention was to use those algorithms in the platform in order to have some alerts issued by the platform for potential bid rigging cases. Unfortunately, now we have this huge amount of data, but we lack of IT experts. And when I say IT experts, I don't mean a person who know how to use a computer. We need people to write codes, to write algorithms which can help us in the future to detect potential cases of the infringement of the competition law. I don't know how is the situation in Georgia, but in Romania, all the case handlers within the Romanian Competition Authority are public servants, and they are paid with the same amount of money, and this applies also for our colleagues who work in the IT department. Unfortunately, in the private sector, the salaries are at least three times better than in the public administration in Romania. And my hope, because I don't want to finalize my intervention on a negative note, my hope is, and I think Romanian government and also the Romanian parliament somehow understand the problem we face, and because in the future in competition I see more than 50% of our activity will be dedicated to digital sector. Together, as I mentioned before, together with our government and parliament, we will find a solution to modify the law in order to allow the competition authority to pay better the IT specialist. So thank you so much again, and looking forward for your questions.
Thank you, Mr. Bellacureno. I think that the same problem has our competition agents regarding the salaries and the IT specialists. But these figures, you know, this Samsung case, 25 million euro fine, it's just not real figures. Not pay attention to that, because we had no such amount so far as a fine in Georgia, and not pay attention to this amount, you know. The last but not least, our honorable guest from Turkey, Bulet Açma. You are welcome, and also I'm happy to see that you have quite fruitful background in sustainable development studies as well, yes. And this is closer to me, to be frankly, than competition and digital markets. But yeah, the floor is yours.
Thank you very much, President. It's a big pleasure to be here and to give a speech, a lovely country. I have been many times in Georgia. It's like my second country. Then I always share with some issues with my Georgian colleagues here. Then today I would like to talk about the competition policy enforcement in the digital markets in Turkey. First of all, let me to give some explain about my presentation and attending this conference. As a last minute, I prepared this presentation, then it is still draft. Then I'm actually not directly interested in the competition policy or consumer protection, but as the chair mentioned, that sustainability interest in everything, you know, as everything need the more sustainable issues, more sustainable side anymore. First of all, it's a big pleasure, and I would like to give a special thank to Georgian Competition and Consumer Agency to invite me, even it's a last minute. It doesn't work. Big one, yeah, big one. Is it first one? Big one. Ah. Thank you very much. As you see, digital marketing, including everything, it's a very problematic area, actually. This is for competition and consumers. First of all, give me explain about the Turkey situation. There are no digital specific competition law rules in Turkey. In October 2022, Turkish government published draft amendments, the Turkish Competition Act, proposing to introduce a new obligation that specifically target digital platforms. The government published a revision of the original draft in November 2023, last year. The proposed regulation largely mirrored the operation of the subsidiary provision in the EU Digital Markets Act through the further in the certain respects. Still pending some passage of the new rules, and digital market remain an enforcement priority area for the Turkish Competition Authority under existing. The Turkish Competition Authority still working on hardly how can we connect with the EU Digital Act in the near future. Also, as I mentioned before, I just prepared this presentation to give a speech about briefly what's happening in the Turkey as a digital marketing and what's going on in the digital market in Turkey. What rules govern competition in the digital markets in Turkey or Turkey? There are currently no digital specific competition law rules in force in Turkey. Digital firms are subject to general competition and consumer protection laws. Applicable to firms under the Act No. 4054, on the protection of the competition, APC. No special rules or the exemption are applying to competition in digital markets. As you see, there is a big fixing. How can be regulation is the digital marketing, especially not only developed countries but also developing countries. As you see, there is a many issue, which is the regulation, which is the doing some act step by step in the Turkey or anywhere. What's the status of any forthcoming digital regulation in Turkey? As I mentioned before, 2020 Turkish Competition Authority initiated a sector inquiry into e-commerce platform. In its final report published in April 2022, it made policy recommendations applicable to a wider set of the technology companies beyond e-economics platform following this recommendation in October 2022. The Turkish government published a draft regulation on amending law of the protection of competition revised by the later draft on the November 2023. This is a still draft regulation. The draft regulation proposed amendments to the APC that in several places track the language of the EU Digital Markets Acts. As you know, Turkey, since 50 years, waiting for the joining the European Union. We are still waiting for on the door of the European Union. It is not acceptable, especially as a competition and some regulation. It is a big damage for Turkish economy and Turkish law. What procedural safeguard does the draft regulation include? Procedural details have not included the draft regulation yet, but given the draft regulation contains a set of rules proposed to amend the APC, we would expect the procedural safeguards and process set of under the APC to apply, such as the right to judicial review of TCA decision, 15, the right of the access to file, 12, and the right of the heard before the TC makes a decision remains. And are there specific rules governing digital platforms' relation with the publisher in Turkey? Actually, there are no any rules in the draft regulation which regulate digital platform relation with the publisher. Also, another question, will the TCA need to establish effects of the certain conduct in order to establish a breach of the rules? No, the TCA is not required to establish the effects of the conduct to establish a branch of the rules proposed under the draft regulation. Another question, can firms defend or objectively justify their conduct under the draft regulation? The draft regulation doesn't contain any provisions that allow the objective justification or defenses. In fact, it goes beyond the DMA, which is as well being subject to overall principle and proportionality, has narrow defenses to cover public health and public security. And cases where the gatekeeper can demonstrate that complaint with the obligation wouldn't acceptable. As you see, this is also such kind of the competition. And as a lastly, what is the current enforcement practice with respect to the conduct with the expect to be addressed the digital regulation in Turkey? Investigation into trendful use of the business data last year in July. Also investigation into Google online advertising service. Fine against Meta for data sharing between platforms last year, November 2022. And investigation info Google search April 2021. Investigation into Google AdWords, November 2022. Is a new regime competition based, or does it target other types of conduct, such as consumer production, moderation of the content, or privacy? This is a very good question, especially the proposed regime is principled competition based into many of the rules having been inspired by the DMA. The draft regulation touches on issues related to do usage, but doesn't address other issues relevant to digital platforms, such as privacy or content moderation. Thank you very much for your listening me. As I mentioned, I just prepared some briefly what's happening in the Turkey as a competition and regulation. Thank you very much for your listening me.
Thank you, Mr. Açma, for the interesting insights in Turkish regulations. Now, as I understand from our schedule, we're very short in time. Now we have to move to our audience, of course. But before we move to our audience, I'd like to summarize and maybe give you one general topic and question for the discussion. You know, what we are discussing now, finally, everyone, regulators, markets, consumers, everyone should, we should ensure that markets are competitive, markets are consumer friendly, and at the same time, markets are innovative. And here is kind of trilemma, what we have to consider, whether these three goals can be achieved simultaneously, or whether in general these three goals coexist in total, and at the same time it should be considered whether it is possible to kind of assign weights for these three goals. Which one kind of, whether when we put in priority, say that competition is the first priority for us, or competitiveness or innovativeness of the markets, or final consumers' rights and their kind of interest should be taken in account is a number one. This is general kind of topic for discussion for all of the members of panels, and if you wish, we can start this answer and share your opinions, and then we can move to audience and their questions. Is anyone? We have no microphones. Can we? Yeah, sorry. I occupied microphone, and there is no other. Yeah, of course, Mr. Achman, you can start.
Thank you very much for giving a time for sharing some things. Thank you very much. As I mentioned before, Turkey still is waiting for the joining the European Union. Even they don't accept it, joining the European Union, but we just getting more and more some rules and some regulations, some laws from European Union, especially in the Digital Market Act, in Digital Market EU. Then it can be a big opportunity for us to share with other countries about how can we get more and more discipline for customer relations, customer protection, and especially competition. It's a very important issue. As you know, as economically, most of the firms going to more monopoly structures is a big problem, especially for developing countries. Maybe developed countries can have some solution for this matter, but it's very important for developing countries like Turkey and Georgia and somewhere to put some regulation, to put some laws in order to reduce the monopoly structure, especially as a firm level. Then I want to indicate this one. Thank you.
I want to answer to your question with a very short answer. In my opinion, I think for our society, all of us should encourage companies to innovate, especially in digital sector, but at the same time, competition authority and consumer rights authorities should take care that those companies follow the competition law and respect the consumer rights.
Thank you.
Yes, thank you. I think we already touched on that yesterday. To what extent do consumer protection goals and competition laws exclude each other? But I think they rather complement each other. There has to be a certain base level, of course, of regulation. Think about environmental laws, which are there for good reasons, and to exclude competition on that issue there. And I think it's good to create a base layer. But I mean, the main idea should be that the markets are open and open to innovation and future developments, and it's very important to have that in mind too.
Yeah, okay, so now on the last one, so much has already been said, but I want to reiterate, I think that all those objectives go hand in hand. And I think we should keep in mind, although I agree that digital markets have some particularities, the main objectives of competition laws do not necessarily change, because what I think is very important to keep these markets fair and open and to ensure a level playing field. Because, for instance, in Austria, the vast majority of companies are small and medium-sized companies. So having said that, for them it's extremely important to have a level playing field and to be able to compete also in digital markets. So I think we have to keep that in mind, that whether it's industrial policy, consumer protection, It should all go hand in hand, because that's for the great benefit of all market participants, may it be consumers or companies.
I'd like to add one thought, maybe, is that in the recent years we have switched back with regard to the enforcement of competition law, that we talk about fairness a bit more, and also about consumer choice. And there is also a common idea that in order for competition to work effectively, consumers actually need to be well informed, and they should have also a choice at about a certain point. And much that was we talked about, for instance, that we did at the Bundeskartellamt was about the data that you give away in digital markets and how you are able to control that. And there we share, for instance, we even are close to applying data protection law, and that has to be, those rules have to be effective in order to provide the very basics or the foundation for any economics or any industry that can be built on that.
Thank you to our panelists for the interesting insights, and I think that now, if there is a question from the audience, you can raise hands. I encourage you, maybe 1, 2 questions. I think this discussion goes quite clearly. It means that everyone understands everything. Thank you for that to our panelists. It means that our panel is kind of successful, because the topics that we raise today somehow relates to everyone, because we at the same time are businesses, but on the other hand we're consumers. All of us using all these digital platforms, especially those that you mentioned a couple of minutes ago, the large platforms, Facebook, Amazon. The only, I think, Romania and Amazon we have not used so far, but if it increases in size, we can easily kind of get this and access this platform as well. Thank you to panelists. I think that we can thank by saying them. Thank you. Have a great day, guys, and thank you.
Thank you. Thanks to our esteemed panelists for their valuable contributions and shared opinions and expertise. We will now take a break, so please rejoin us at 12.